Hey folks, Ben Wittes here. Welcome to this week's Trump's Trials and Tribulations, which this week have been highly concentrated in a single court down here in South Florida. So I'm coming to you from the Mar-a-Lago Auditorium. And I'm joined today, of course, by Anna Bauer, who has gone to the Mar-a-Lago bathroom studio. And the only one of us who isn't at Mar-a-Lago is Roger Parloff, who summers in France. And so he is joining us from the Jura studio somewhere in the Jura. We got a lot to cover today. It's almost all in South Florida. Before we do that, however, we're going to take a quick hop to our other three ports of call, you might call them. So Anna, let's start at the Georgia Court of Appeals, which took the Georgia case from the state of deep freeze that it was in to like liquid nitrogen level frozen. Tell us what happened.
Yeah, so if people remember, the Georgia Court of Appeals currently has a pending decision before it regarding the effort to remove Fani Willis from the Trump prosecution. There were 9 defendants who originally joined that motion. And as a part of that, Misty Hampton, who is the former Coffee County election supervisor, did not ever join the motion. So when it went up on appeal, there was a stay that was issued by the Court of Appeals only as to those defendants who were parties to the appeal. So Trump and those other defendants, Misty Hampton was not included in that. So there was some suggestion. I pointed this out on a previous Trump trials episode in which there was a potential scenario in which Misty Hampton, maybe some of these other defendants, could proceed to trial at some point, even before the Court of Appeals issues its decision. We think that that decision is likely to come sometime in the spring of 2025. But Misty Hampton went ahead and applied to the Court of Appeals for a stay. She argued that if the Court of Appeals ultimately does disqualify Fani Willis, then even though she didn't join the motion, it would affect the entire case. She has not been severed from that case, that kind of thing. And the Court of Appeals, we heard yesterday, did grant that motion for a stay. So it indicates, I think, to the other defendants whose cases are not stayed, that if they did apply for a stay and in the way that Misty Hampton did, that the Court of Appeals would also stay their cases as well. I also wonder, and I'm curious, Ben and Roger, if you have thoughts on this, if there's anything that we can maybe kind of guess at in terms of any indications from the Court of Appeals as to what they're thinking. I think it doesn't really tell us anything about the merits of what they will ultimately decide. But I do think, again, that it may indicate that they would ultimately potentially decide that, yes, those other defendants who didn't join the motion would also, have Fani Willis removed from the case, even though ostensibly you would think that the motion would be waived because they didn't join. So any thoughts on that from either of you?
Yeah, I have. So the Georgia Court of Appeals is a respectable court, and I don't want to cast aspersions. But when every interstitial judgment goes the same direction, it does begin to look like the court is hostile to the side that it's consistently ruling against or sympathetic to the other side. Now, in this case, there's lots of potentially good reason for that. Remember that the district court order that is under appeal by Fani Willis contains the phrase about her testimony and that it was accompanied by an odor of mendacity. And so you are starting from a position in which, her position is subject to reasonable suspicion, and the district court itself harbors some suspicion about it. And so I don't mean to sound like I'm sort of condemning the Georgia Court of Appeals, but I do think as these incremental judgments rack up that all go against her, you have to start wondering, is this setting up a reversal and a disqualification?
Yeah, and I should say for people who haven't seen the order, it just very summarily kind of applies the stay. There's no reasoning in the way that you would usually see in other, maybe in federal courts when there's a stay that is not, just kind of really short term administrative stay. Here is just kind of, we don't really have any reasoning, so we don't know exactly what the Court of Appeals is thinking, or why exactly they think that there's good reason for Misty Hampton's case to be stayed. But again, I do think that it indicates at the very least that one, other defendants who want to have their cases stayed by the Court of Appeals would be able to do so. And then two, that maybe the Court of Appeals is thinking that if Fani Willis is disqualified, then all of the defendants would have her disqualified from their cases as well, even if they didn't join that original motion.
All right. So we can now, just in time for the Washington case to presumably come out of deep freeze, which will happen either tomorrow or Monday, barring a more extreme Supreme Court opinion that at least I'm expecting. The Georgia court is now, there will be nothing happening in Fulton County until the case is argued and decided at the Georgia Supreme Court, right?
So that's right in terms of the actual substance of the pretrial proceedings themselves. But I will point out two things. One, Mark Meadows, who previously was litigating his appeal of the effort to remove to federal court, the 11th Circuit rejected that appeal. He has been in the kind of in stages of he's either got to go to the Supreme Court or give up his litigation at this point. And he last month applied to Justice Thomas, who is the justice assigned to the 11th Circuit, to get an extension on his petition for a writ of cert. Justice Thomas granted that. And so his new deadline was supposed to be June 27th. That's today. But yesterday we got a notification on the docket that Mark Meadows had applied again for a 30-day increment. That's usually how it goes in terms of extensions. And he now has I believe it's July 27th deadline. I do expect that he will appeal that 11th Circuit decision. And I will point out that one of the reasons that he included in his application to get an extension is that he wanted the benefit of seeing the Supreme Court's opinion in the presidential immunity case, because they're very closely related types of analysis that is at work here.
Right. The issue isn't closely related, but the mode of inquiry is.
Right. Well, right. Because it's supremacy clause immunity versus presidential immunity. And there's these questions about official acts and acting within the scope of your duties, that kind of thing. And so, we will see probably some movement with Mark Meadows at the Supreme Court. And then also with Meadows' case, he has an ongoing Politico. Kyle Cheney just published a piece about this that folks should read if they're interested. But Mark Meadows also has an ongoing dispute with the National Archives about basically things that relate to what he was doing while he was at the White House. He's been trying to get certain communications and things that are in the possession of the National Archives because he thinks it helps support his supremacy clause immunity and some of his defenses. So there is some ongoing stuff with that is more not necessarily the exact substance of the pretrial proceedings, but these kind of, things that are on the periphery that we'll be watching.
Yeah, and just in the spirit of always commenting on counsel performance and quality of counsel, Paul Clement or Mark Meadows is represented on the appellate level by Paul Clement, the former Solicitor General. who is one of the very, very finest appellate lawyers in the country, and somebody who has a real rapport with the justices. And so, there are, and Meadows, unlike Trump, has been pretty consistently represented by first-rate counsel. I think McGuire Woods handled uh, uh, the the
The
the
supremacy clause.
litigation,
Yeah.
the supremacy clause litigation, or the removal litigation, and now Clement has taken it over for appellate purposes. So the Supreme Court will have, don't be surprised if the Supreme Court agrees to hear this question. I think both the district court and the 11th Circuit did a less than ideal job in the 11th Circuit's adjudication was a little bit nutty. And the district courts was not the inquiry that I expected, to be honest. And so I wouldn't be at all surprised if the Supreme Court decided to take this. And I'm sure there will be howls of rage from a lot of commentators if that happens, but you won't hear one from me. I think there's a pretty decent case for the Supreme Court to take a look at this removal question. All right, next stop. Back to New York. We have a sentencing coming up. We have a debate tonight. This is the only reference to the debate you're going to hear on Trump trials and tribulations. And the reason we're mentioning the debate is that Trump is very excited about the loosening of the gag order, which happened the other day, in light of the fact that, as he put it, it happened just in time for the debate with Crooked Joe. That's in mostly all caps on Truth Social. So do either of you want to describe what happened in New York, or should I do that?
Well, Ben, I have been, Judge Cannon, as folks will remember, scheduled over 3 business days worth of hearings, but because it was a Friday and then went into the next week, I had been in Florida for almost a week.
Yeah, so, you're stuck in the bathroom at Mar-a-Lago.
I'm still stuck in the bathroom at Mar-a-Lago. So, Ben, why don't you tell me what happened while I was stuck in federal court without my phone?
Okay, so as you may know, Anna Bauer, there is a debate tonight between Donald Trump and Crooked Joe Biden, as we call him. And there was a problem for the former president, which was that there was this gag order that prevented him from doing something that presidential candidates traditionally do at debates, which is attacking witnesses and the other components of the justice system from their criminal trials. That's normally what you do, at a debate. You attack the witnesses who testify against you and the jurors as well, and the court staff. You wouldn't want a debate in which the president wasn't able really to go after Stormy Daniels and Michael Cohen adequately, or so Trump moved to get rid of the gag order, and to nobody's particular surprise, Judge Merchan loosened it significantly. He is now allowed to talk about witnesses. I think he is not still allowed to talk about jurors, but I haven't actually read the order. The entire order will lapse at the time of his sentencing, however, which is only a couple weeks from now. So he is very excited about this. He's, as I say, crowing about it on Truth Social, and expect him, I think, really does come right in time for the debate. So expect him tonight, if he attacks Michael Cohen and says that he should be shot and Stormy Daniels should, face trial for treason, he will not be sanctioned as a result. I've said all that sort of tongue in cheek, but that's the long and short of it.
Yeah, and you mentioned witnesses, you mentioned jurors. What's the rule now regarding the prosecution team?
Well, they're never covered I think he was always allowed to talk about Alvin Bragg. I think it is now loosened as to the prosecution team.
Okay.
But it's, you know,
I think he's also allowed to attack the jury in sort of
jury
a collective
generally.
way.
Right. He's
But
allowed to talk about how awful the jury was, but we're not naming specific people is basically the construction here.
Okay, and anything else with respect to sentencing that is coming up? It's on the horizon on July 11th. Is there any further developments there?
Well, the only major one, and is that our Brookings colleague Norm Eisen and some of his staff wrote in Just Security. Let it not be said that I am willing to talk about material published in that other publication. They produced a substantial study of sentencing under the creation of false record statute in New York. And it's a fairly detailed analysis of a large number of cases under the same statute, which found that it's a little bit equivocal. It found that a custodial sentence in their judgment would be warranted or would be within bounds, but a non-custodial sentence would also be within the reasonable discretion of the judge, given the previous sentencing history under the particular statute. So it's a little bit equivocal, but it's and I have not read the entire thing carefully. It's on my weekend reading list, but it's the most substantial thing that I've seen yet on what sentencing under the statute looks like.
Great. Well, Lawfare will be covering the sentencing, so we will be there. We will be back in New York. But I think that if that's all on New York, we can move on to the classified documents case.
Well, we've got to make a quick stop in Washington for what's basically an administrative announcement, which is that based on the Supreme Court's normal schedule, we are expecting a decision in both Fisher, that's the 1512C obstruction case, and the immunity matter either tomorrow or Friday or Monday. Whichever day it happens, we will have a live stream later in the day at some point, depending on schedules. If the two opinions come out at two different times, we will have live streams each day. So keep your eye on the social media feed, keep your eye for material supporters. And if you're listening to this on YouTube, you should become a material supporter. Keep an eye on the Patreon and your email for times. We have to keep this fluid because we don't know which day these are coming. We also expect that, or at least I expect that in the event that this matter is remanded to Judge Chutkan, which I think it will be, there will be relatively quick movement in the case. I just say that because she has signaled at every stage that she has a sense of urgency about this case, even if her higher ups at the Supreme Court do not. And so I expect that whatever latitude she has, she will employ. And so I think there will be a lot of movement next week or the week after at the district court level, which we will try to be all over. So just keep your eye on our feeds. I can't announce anything in advance because I don't know when stuff is going to happen, but we will be as active as we need to be, including over the July 4th week. Okay.
And if I can just add my periodic bummer announcement, if the Supreme Court had denied cert on the day it granted cert, or if it had denied a stay, even, I guess, we would be halfway through the DC trial right now, with the jury likely to start deliberating on July 22nd.
And if Judge Chutkan if the opinion comes down tomorrow and Judge Chutkan gives Trump the 88 days that she promised him for reasons that we will not repeat this evening, when would a trial begin?
Jury selection could begin around September 23rd. That means that you wouldn't you would get a trial, I think, starting October 7th, and you might get a verdict by November 22nd. So pretty well after the election.
All right. On to South Florida. Anna, you have spent a lot of time in court the last few days, but we've already covered one of those days. In last week's Trump Trials and Tribulations, we talked about your day-long discussion of the Appointments Clause and accompanying statutes with Judge Cannon. So for those, we're not going to spend time on that, but just so that people understand the sequence of events, give us a 1 to 2 minute overview of the Appointments Clause discussion so that it situates the Monday and Tuesday discussion. So this happened a week ago tomorrow.
Right. And we do have a long discussion about that on our previous episode. But for those who didn't listen, the Appointments Clause issue is one half of one motion that Trump filed to dismiss his charges based on the Appointments Clause of the Constitution, as well as the Appropriations Clause. And Judge Cannon both scheduled a morning session to hear from the prosecution and the defense, but also heard from 3 non-parties called amici, and it included a law professor. It included counsel for former Attorney General Edwin Meese and others. And then it also included Matthew Seligman, who was representing parties who were in opposition to Trump's motion to dismiss. So we had this all-day hearing on that issue. The basic gist of it is that it's this question about whether or not the Attorney General has statutory authorization to appoint special counsel Jack Smith. Trump says no for a variety of reasons that deal with statutory interpretation issues, and then also makes the argument as well that Jack Smith, as the special counsel, is what's called a principal officer. And under the Constitution, if you're a principal officer, then you must be generally, the general rule is that you must be nominated by the president and basically put into your officer position with the advice and consent of the Senate. The argument is that because Jack Smith is, in Trump's view, a principal officer, and he was not confirmed by the Senate, then therefore his appointment was unlawful and that the prosecution must be dismissed. Ben, Roger, is that a pretty decent summary of what the issue is?
Yeah, and for more on that, if your interests run in the Appointments Clause direction, as mine do, because literally this issue of special prosecutors appointed under various mechanisms and the subject of their resulting constitutionality or unconstitutionality has literally followed me my entire adult life. There has never been 3 years of my life where I did not have to think about Appointments Clause questions and special prosecutors. And my interests run that direction. If yours do too, or if you want to get in touch with my inner spiritual being, Anna has a dispatch on the subject on Friday's hearing, and you can tune in to last week's Trump's Trials and Tribulations and hear Marty Lederman's thoughts on it and Lee Kowarski's thoughts on it. So we have a lot of material for you on that argument, just not today.
But that argument actually, though, is quite important because it relates to this second argument.
Wait. I had a great setup for this.
Sorry. Okay.
You
I messed it up.
You messed it up. But we're going to leave that subject because that was so Friday. And we then had a whole weekend. And during that weekend, we went from talking about whether Jack Smith was unconstitutional as special counsel because of his appointment, or whether he's unconstitutional because of the way he is funded. And Anna, did that take all day on Monday or just half of the day?
So it took up a good portion of the day, but it was the morning session. In the afternoon session, we also had a hearing on the government's motion to modify Trump's bond conditions such that he would be restricted from talking about law enforcement officers in a way that brought significant and imminent and foreseeable harm to them.
All right, so let's break this up. And Roger, you should jump in anytime because this is going to devolve into me interviewing Anna about 2.5 days of testimony. And you should A, participate in the interview, and B, insert comments as necessary and useful and interesting. So let's start with the funding question. Normally, when the Justice Department conducts an investigation, the court overseeing a prosecution resulting from that investigation doesn't really inquire about, which tax dollars from which account funded, did your postage stamp on this letter fund this motion in the litigation? Where did the money come from is not really a question we tend to ask about federal prosecutions. Why does how Jack Smith pays his staff, why is that an issue in the litigation?
Yeah, this argument is one, it takes a little bit of explaining, so bear with me, but keep in mind this argument that Trump is making about Jack Smith's appointment being unlawful. That relates to this appropriations argument. There is a clause in the Constitution, the appropriations clause, that basically says that any monies that are paid out by the United States Treasury have to be authorized by law, so by a statute that's enacted by Congress. And Trump's team has pointed to the appropriations clause to then say, oh, well, actually, because Jack Smith wasn't lawfully appointed, then that means that he cannot, under the appropriation statute that DOJ, the bucket of funds that DOJ is drawing from, which is called the permanent indefinite appropriation. It was created by Congress under the statute to basically fund the investigations and prosecutions of special counsels, either who were appointed under the old Independent Counsel Act that no longer exists, or by other law. And so you would think Jack Smith falls underneath that statute because he was appointed by other law, by the Attorney General. But again, it goes back to this appointments argument where they say Jack Smith wasn't lawfully appointed, so therefore he wasn't statutorily authorized to use these funds to prosecute Trump. And therefore, that violates the appropriations clause, which says that you have to have some kind of statutory authorization. So therefore, the whole prosecution is unconstitutional and the charges should be dismissed.
Okay, but I don't understand that, because if the matter is entirely derivative of the appointments clause question, then what added work is it doing for the defense? If the appointments clause motion rises and falls on the success of if the appropriations clause matter rises and falls on the strength of the appointments clause matter, then what work is it doing?
So they did admit that part of their argument relies on the appointments clause argument, but there's a separate alternative argument that they're making as well, Ben, that relies on this language underneath the appropriation statute that creates the fund that Jack Smith has been drawing from. And in that statute, it uses the term independent counsel appointed pursuant to other law. So the big focus is on this phrase term other law. That's where the appointments clause argument comes in. But they also focus on the meaning of independent counsel in that statute. And they're trying to say that these days, the special counsel basically and it's kind of in tension to some of their other arguments, right? Because they were saying on Friday that, oh, Jack Smith is answerable to no one, and this is such a problem because he has no oversight. But then on Monday, they're arguing he's not truly independent because he's, has all this oversight from the attorney general. And there are these regulations that say that the attorney general can do this and that to basically, tell the special counsel what to do. So he's not independent in the real meaning of the statute.
But this is but hang on a second. I'm burdened here by knowing the history of this with an unnerving degree of precision. The term independent counsel in this rule is a reference to independent counsels appointed under the Ethics in Government Act, the so-called independent counsel statute. He's not one of them, but it is or other law, right?
And it's a lowercase I and C.
Yeah, and or other law plausibly refers to the regs under which he was appointed. Why is this even hard?
So they're reading it to be that there's two necessary conditions, like it has to be under other law, but then you also have to be sufficiently independent. And that they're reading that clause to kind of mean, either it's under the Independent Counsel Act or it's an independent counsel appointed pursuant to other law. So there's two conditions within that latter phrase.
Right. But of course, then you run smack into the appointments clause problem, because they're arguing for appointments clause purposes that he's too independent already. So now if you demand that he be more independent, not to, to draw on this particular fund, then you're kind of creating a mousetrap.
Yeah, Ben, it was actually kind of crazy because one of Emile Bovie's main point when he stood up to argue this is that there's an irreconcilable tension within the governments. Because remember, the government is kind of doing the same thing, but I think to a much lesser extent, they're saying, well, yes, it is an independent counsel. They say this on Friday with the appointments clause. He is an independent counsel, but he has all this oversight. And so he's not a principal officer. He's an inferior officer. And that is consistent with the appointments clause. And so, so hold on one second. I am being interrupted. Okay, never mind. I'm good. Okay, sorry about that. And then on Monday, the government is saying, well, no, the special counsel is sufficiently independent. So it goes a little bit both ways, but Emile Bovie really just was kind of ignoring the fact that the same tension that he's pointing out in the government's argument is to a much greater extent actually in his argument.
Yeah, the government has a nomenclature tension where they're trying to use a statute that was created during the old independent counsel era to fund one appointed under the special counsel era. Bovie has a substantive tension, not a nomenclature tension.
Can I butt in for a moment?
By all means.
I think it's been a little bit of a moving target also, because I think the original brief, they said we're raising an appropriations clause issue, and then they never really explained. They jumped immediately to a statutory issue about this question of, can you use the permanent indefinite fund for something that isn't technically the independent, that, it isn't the independent counsel of the Independent Counsel Act. But and meanwhile, if there was a constitutional question, there is, there is an appropriations clause question about whether you can, or there was before when this was filed, about whether you can this indefinite fund is not re-upped every year and approved by Congress. So it's something that Congress can't. It's sort of, you've diminished Congress's power of the purse. They can't at the end of this year say we want to defund this guy. And but just shortly after he filed the motion, the Supreme Court decided another case that sort of said, no, that's not a constitutional problem. If Congress authorizes a fund that's available for many years, that's fine. And so that sort of vanished. And I think that they've been trying to puff it up with some constitutional basis since then. And because the pure statutory question, there's also just a standing question. Why does Trump get to, why does it matter to him which pile of money this thing is being funded by? The DOJ has the budget to fund this. If that's what you want, he can do it, but what's it to you?
Well, I think the answer to that is, if you were constitutionally funded, you wouldn't exist, and then you wouldn't have been able to indict me.
Well, no, because the DOJ has said we have other sources of budget that would have covered this, and we have the money. And
so go ahead, Roger. Sorry.
And then just one last point is that, to give you an idea of how weak this argument was, Judge Cannon invited the three amici to address this question, the appropriations question, because they had only addressed the appointments clause question. None of them did. One of them, the Mies Calabrese group, represented by Cher, filed a supplemental brief, but it addressed none of the questions it was supposed to. It was just sort of a rebuttal. And then Josh Blackman and Tillman filed nothing. And how rare it is for them not to weigh in. That's sort of a sign in itself. Ouch. That this is a weak argument. But she is apparently into this. Well, I'm judging largely from what Anna wrote.
So let me just say, let me say a few things in response to what you guys were raising about whether it's a constitutional issue and whether there's standing. Those are two things that did come up during the hearing that Judge Cannon specifically asked about. And she ultimately seems to be of the idea that there is a constitutional issue, because even though DOJ represented at this hearing that they would have had alternative sources of funding, and that even if they do not continue to fund Jack Smith from the permanent appropriation, that DOJ was fully prepared to continue to fund Jack Smith's work through other appropriations that are just within the department itself, as opposed to this kind of special fund for special counsel work. But she was very interested, though, in this question of whether it really did raise an appropriations clause issue. And she had a back and forth with James Pearson, which she was like, well, she was getting very frustrated with him because he kept saying, well, Judge, this is just a pure statutory interpretation question. There actually is no constitutional issue implicated with the appropriations clause. She over and over again pressed him to try to explain that. And ultimately he had to stop and say, Judge, you know what? This isn't a hill that I'm inclined to die on. That was his exact term. So if it is how Your Honor is inclined to think, basically, then that's not something that we're going to, really fight. So that was the constitutional issue. The standing issue, Trump
But
has
Bovee, by the way, wouldn't die on any hill because he's already dead. And since he's the undead, um, it's actually, he's uniquely positioned to cede that ground.
Okay, Ben, you have to explain that now. You can't just say that and not explain it.
Yeah, so we have a joke internally that Bovee has a vaguely vampiric sepulchral demeanor. And I say that with love. He's a superb lawyer, and but he does sometimes look like he crawled out of the crypt in order to make an argument.
Okay, well, anyway, so so the standing issue, though, Judge Cannon also asked about. Bovee cited this Ninth Circuit case called McIntosh, and that I don't need to go into, and that was not in the same posture that this is, or dealt with the same type of statutory framework. But he cited that case as a way of saying, well, the harm, the injury here is that there's an imminent threat to liberty. And so he's trying to frame it in that way, as opposed to saying, that there's already been some kind of injury. It was almost this kind of perspective reference to this imminent threat to Trump's liberty. So that's the way that the defense is dealing with the standing issue. Ultimately, the Justice Department kind of walked back the idea that they wanted to even refer to it as standing. They were saying more so at the end that it's more about the point that there's not really any prejudice here to the defendant, because ultimately nothing about the fact that the fund, whether you had the correct fund doesn't really kind of matter, because either way the prosecution would have been funded in some way. So that's, yeah, Roger, go ahead. You got something to add to that?
Just one other butt-in point I wanted to make was that I think in both the appropriations clause hearing and the appointments clause, she has been really angling for additional factual evidence. She wants to know, did Attorney General Garland approve the indictment? She wants to get inside, and it's not clear. To me, at least, it sounded like she is still considering, will she send interrogatories or something to the DOJ? And same with the appropriations clause. She wanted more factual, and nobody but her, this is all her. Nobody wanted and asked for an evidentiary hearing on either of these issues. And so she on her own invited the amici and everybody, should this, do I need, and everyone, and of course, by then Trump begins to get say, well, yeah, you might need one, but this is her driving the car again, and this investigating the investigators. And I do think that one hill they might be, I mean, one thing, I don't think the government wants to start getting into, did Attorney General Garland approve this? Did he approve? That is really
No, they will not talk about that.
Yeah.
And this was a very contentious point in the Friday hearing when she was pressing James Pierce on this. He over and over again said, I'm not going to get into the department's internal deliberations. She said, why would there be any heartburn about answering whether the Attorney General approved the indictment? She was very unhappy with them about that. But Roger, to your point, on the issue of the impact of the Consumer Financial Protection Bureau case, she was actually really focused on that in a way that the parties didn't even argue. She's focused on this issue of separation of powers, that might be implicated by the fact that there is an uncapped permanent indefinite appropriation for the special counsel. So she was asking these questions that were, do you know of any cases where there are constitutional separation of powers issues and implicated by an unlimited spending? And then she went kind of line by, this is again, one of the more remarkable aspects of what was going on, is that she was going, line by line in the expenditures of the report of the special counsel's expenses, saying, oh, well, what's this? And is this what I think it means? And that kind of thing. So it was, again, to your point, just really focused on getting additional factual information that no one had even raised.
Yeah.
All right.
Okay.
So we're going to play a little game, which is to try to figure out what the chances that Judge Cannon slips up and gets something sent to the 11th Circuit. And so for each of these motions, which would produce a dismissal if granted, I'm going to ask each of you to assign a probability that she grants it. So Anna, appointments clause, what do you think the chances are that she dismisses the case on grounds that Jack Smith was unlawfully appointed?
Oh, Ben, I don't know.
Give me a number.
The appointments clause issue, she did come back. I just need to reason this out a little bit. I don't like just saying the number. The appointments clause issue, I said initially on Friday, I thought she was going to pull a canon, which is write like a 20-page opinion explaining why she thought Trump's arguments were so good, and then write one paragraph at the end saying, but I cannot. No. I thought on Monday, though, she came back to the appointments clause issue again and again as it related to these appropriations clause arguments. And I got more of a sense that maybe she's really seriously considering that Jack Smith is a principal officer and that he was unconstitutionally appointed. And so I mean, it's 50-50 to me. I feel a little bit like I did coming out of the special master hearing last, what was it, 2022 now. And I wasn't really sure what she was going to do, but was pretty concerned by some of her questioning. And I feel a little bit the same here. I think she's really unpredictable.
All right, Roger, what probability do you assign to a grant of a dismissal on basis of the appointments clause?
Well, I wasn't there like Anna, but I have always thought that given who she is and who she wants to be, that this is something she might grant. And I don't think it's the thing that would get her reassigned, because I think she has support on the Supreme Court and would have it. And
but it would be ripe for appeal. That's all I'm calculating.
I mean, it'd have to be appealed.
I
think it would be reversed, but still, I think given who she is, I think it's possible.
So 50-50?
Yeah.
All right. What about the appropriations clause, Anna? What are the chances she says, you're lawfully appointed, maybe you're lawfully appointed, or maybe you're not, but in any event, you're unlawfully funded. So I'm dismissing the case.
I don't think she dismisses on the issue of the appropriations, but she's really concerned about the special counsel spending. I don't think she's going to dismiss, though. So I don't know, 15%.
All right, let's move on. We will do a calculation at the end of the thing of the probability that something ends up in front of the 11th Circuit among these motions. But
by the way, on that one, if she does, I think the chance of reassignment is higher, because I think it's wackier, and I think it's her. It's just so driven by her, and it's judges are not supposed to be litigants, and they're not supposed to, if they do, sometimes it makes sense for a judge to say, well, wait a minute, I think there's a constitutional issue. But if every single frickin' time they do that, it favors one side, it begins to look like something else is happening. And that's what this is.
Yeah.
Over and over, she brings things up. Last August, she decided she got a bee in her bonnet that there was something suspicious about the way they kept it in the DC grand jury for so long, and only at the last minute brought it here. They were trying to do something tricky, and she's still investigating that. And she was the first one that wanted to find out, well, what really did happen with Stan Woodward and Jay Bratt back in 2022,
which she still hasn't ruled on.
Right. And so she's got all these bees in her bonnet, all these things she wants to know. This appropriations clause, shouldn't we have an evidentiary hearing? No, not really. We waived it, in fact. No, she wants it. So that's the sort of thing that could get her reassigned.
Yeah, I actually think the appointments clause stuff could get her reassigned too, because I think once the government goes up on something, they have this huge record, and they can ask for a reassignment based on the totality of her performance. All right, so now we move to the afternoon session. We still got one whole day to go after the afternoon session. We move to the afternoon session, and we are talking about gag ordery kind of things. Tell us about what happened at the afternoon session on Monday.
Well, it did not go well for the government. She was very skeptical of the idea, I think, that there was anything that needed to be dealt with at this juncture, at least. She was focused on the fact that under the Bail Reform Act, am I getting the acronym for the statute correct? Sorry, thank you. Under the Bail Reform Act, she was focused on the fact that, there's a focus on safety concerns, but also that the whatever kind of action is taken must be kind of the thing that is like the most minimally or like kind of least reasonably necessary action that the court could take. And she was focused on in that inquiry why it's not sufficient that law enforcement officer witnesses in the case have had their names redacted in the public filings. Roger, as you are well aware, she has felt very aggrieved by the kind of ongoing litigation over the redactions. It's something she's been very annoyed by. And she, said, we had all the, and she went through all the things that had happened with the fight over whether or not these witness names should be redacted. She said the court did redact these names. And so why isn't it sufficient that, these names aren't public? And the government said, well, Your Honor, there are some of these names that are public because there were law enforcement officers who were involved in the case who were doxxed. She wanted to know, well, when were they doxxed? It was in 2022. And what does that have anything to do with the present motion? And she wasn't quite really connecting the fact that the point was that because these names are now public, if there is speech that is, in some way putting officers in danger, then those people could very well be targets because their names are public. They aren't protected by these redactions that she was pointing out. But she was really focused on this idea that, well, did the defense have anything to do with doxing these names earlier? She didn't quite grasp like what it is that was the issue here. And it kind of got her into a really tense exchange with David Harbaugh. And for the second time now, she ultimately ended up reprimanding him, saying, Mr. Harbaugh, I don't appreciate your tone. If you can't be collegial then and professional, then I'm sure one of your colleagues would be willing to take over.
This is what I often have to say to you, Anna, and you never listen to me, and so I end up wagging my finger at you.
Yeah, exactly. So that happened. That wasn't great for them. And she also was focused on the
Yeah,
fact that
somebody just asked, was his tone rude? I mean, did it strike you that his tone was off?
so his tone, it's hard to describe. His tone was one in which you're trying to explain to someone and you're a bit befuddled by the fact that they don't understand what you are arguing. And he was, you could tell he was frustrated, but he wasn't, in my view, he wasn't being rude, but his tone did have an air of, he was a bit, again, frustrated and puzzled by the fact that she couldn't grasp that she had just asked about the redactions. And then he was trying to explain to her why it didn't matter. And she was going on these tangents that were kind of irrelevant. And so, it was that kind of tone of, it was maybe a little bit condescending. I don't know if it was quite there, but it was, a little bit kind of to that. But it wasn't something that I thought was like so egregious that it kind of required her to stop and say, your tone is so terrible, and maybe let one of your colleagues take over if you can't pull it together. He immediately, I will say, apologized, did pull it together, and from then on things were fine in terms of at least the tone. The substance of the argument still did not go very well for the government, and then at the end Harbach did apologize to her, and she accepted the apology, seemed to be fine with it, and so it was just a moment, though, that I thought was remarkable because Roger, at the hearing that you went to the previous month, I believe there was a very similar kind of exchange, right?
Yeah, there was.
Yeah. And so the rest of the argument, Ben, she's focused on this idea that it's not at this time that there's any kind of real reason to think that there is a threat to law enforcement safety. She talked about how when there's a trial, if there are some kind of threats, then at that juncture she would deal with it. The other thing that really she got mad about is that the government suggested that she incorporate by reference fact-finding in other jurisdictions that relate to people who had done things in response to or around the time that Trump had made statements about things. People had gone and attacked people or made threats and that kind of thing. The government, said all these other jurisdictions have there's this and that. And she got very upset that the government wanted her to just take other judicial opinions or decisions and incorporate it into her ruling. She was really, again, focused on this is a factual proceeding and you have to develop your factual record, which, I mean, it is true that the government does have to do that, but it was kind of another example of some of the ways in which she's very, very particular about the way that things are happening. And so anyway, it ultimately is kind of where we left off, where it just seems like she was not totally convinced. I very much think that it is going to be a denial for the government on this issue. And I will say that there were also moments where it didn't feel totally like the government's heart was in it. They did have moments where it seems like a misstep because, for example, they had additional things they wanted to put into the record, but they didn't really have them prepared. And they had to make requests to maybe supplement the record. And of course, she gets very frustrated with that kind of thing. So there were just moments that it seemed like it wasn't the government's best performance. And Judge Cannon was very frustrated with that.
All right. On to Tuesday. So Tuesday, we have a secret hearing in the morning. What do we know about the secret hearing? What was it about? And did you sneak in your fly on the wall disguise and land on Judge Cannon's shoulder and listen to the whole thing?
No, I wish, but I think that would have been a really interesting hearing. It was on the attorney-client privilege issue. Trump has a motion to dismiss or suppress evidence based on the quote unlawful piercing of attorney-client privilege. That relates to the dispute that existed up in the District of Columbia during the grand jury proceedings when the Department of Justice basically was trying to get Trump's then attorney Evan Corcoran's notes that related to some of his communications with Trump about the movement of the boxes and the response to various subpoenas. And the District of Columbia judge Beryl Howell ultimately said, yes, the crime fraud exception applies here. And the government was able to obtain those notes. And so Trump is now arguing that the crime fraud exception should not have applied. So Judge Cannon held this hearing on what she calls presumptively privileged materials. And she also, I believe, Roger, correct me if I'm wrong, but it was also on this grand jury materials dispute that what has been ongoing between the prosecution and the defense. And maybe you want to talk about that a little bit, because I know that's something that you've focused on.
I think that's right, and I'm a little unclear on it too. It has to do with Naughta's counsel Woodward was trying to get the full record on the attorney-client privilege question.
It's kind of unclear, and again, we weren't there, and so I don't know exactly what was discussed. So we're just kind of talking about these things based on what we know from the hearings and the filings. But there has been a dispute over the grand jury material, some of the grand jury materials in DC. And there was at one point, again, Roger, correct me if I'm wrong, there was at one point an effort to get those materials transferred down to from the District of Columbia down to the Southern District of Florida before Judge Cannon. And I think that Judge Boasberg maybe denied that request. Is that right?
Yeah, that's right, James Boasberg, and that was he just denied that. I think in May, and he said, well, it's a fishing expedition, and I think the request came from Woodward, and it seems like, judging from I guess, spoiler alert, there was an order today that we're going to get to eventually that discusses this too.
So let's get there. We don't know what happened in Judge Cannon's.
We don't know what happened.
We don't know what happened in Judge Cannon's courtroom, but she did issue an order following that hearing. Roger, what does the order do?
Well, it ordered, and I think it shows considerably that she's considerably pissed by what James Boasberg did. But let me say first, on this attorney-client question, Beryl Howell made this ruling, and I believe the government has said that everything the government has on the attorney-client question, Judge Cannon now has. The government itself doesn't have certain ex parte presentations that Evan Corcoran was allowed to give Beryl Howell, and I think that Trump's then lawyers were allowed to give. That was James Trusty, Lindsay Halligan, and Tim Parlatore. So I thought, but she thinks something is important is being kept from her still. And anyway, so today she she denied part of, I guess we haven't yet, part of a motion we haven't discussed yet, but she ordered an evidentiary hearing on this attorney-client privilege stuff. And I don't know if it's a way to force the government to go back itself to James Boasberg, Chief Judge Boasberg in DC, and say, look, if there's anything remaining that she doesn't have, let's get it to her. But she feels there's some outstanding factual issues, and I don't know what they are. They are saying that relate to whether I don't have the language in front of me, but whether Corcoran, whether Trump was using the magic language to pierce the privilege, whether Trump was using his relationship with Corcoran to further a crime or a fraud, and so she's contemplating a hearing with exhibit lists and witness lists, and the government obviously was very upset about this. She refers to the fact that the government does not want a mini trial beforehand, does not want its witnesses being have to testify, and of course these would mainly be FBI agents, and as you just said, well, those who haven't been doxxed will be doxxed at this evidentiary hearing. You can't keep their identities secret unless the whole hearing will be closed, which it might be, because she closed this other hearing, because she's taking this attorney-client privilege so seriously. This is an attorney-client privilege that's already been pierced. We know what the Corcoran, we know the gist.
We know what the notes say.
Well, yeah, and yet she's also considering, remember, striking these paragraphs from the indictment, and these would be crucial paragraph, because without the information about Corcoran, all of the counts relating to withheld documents, a number of there are willful retention counts that deal with documents that were seized on August 8th in the search. But there are also about 10, I think 1 through 21 were seized.
Yeah, but a bunch of them are after the fact.
21 through 32 or 21 through 31 were turned over on June 28th. So if you don't know the lengths to which Trump took to avoid turning those over on the 28th, which is what Evan Corcoran tells us. Corcoran tells us he asked Corcoran to pick those out and to get rid of them, and implied he should destroy them. And, without that, you can't really, he can just say, well, I turned them over. What's the problem? And then of course, so it's exceedingly important. Many of the counts of the indictment hinge on whether the Corcoran notes come in.
All right. And so the Corcoran notes suppression motion, Anna, Roger, what percentage chance does she grant it?
I think the question is, I think she mainly, this is another run out the clock thing. It's also, in case if there is a trial, it gives the Trump a ton of discovery. It's always bad to have your witnesses have to testify twice or multiple times. But she also, does seem convinced that something sinister happened up in DC. That's why they did all this stuff in DC instead of coming down to South Florida where it would have been done properly. And so maybe she's going to try to find some distinction and grant this.
Anna, what do you think?
Yeah, I mean, it's really hard to tell on this one just because we haven't been present for the hearing. But I'm inclined to think that she is very.
That hasn't stopped me on anything this evening.
I'm very inclined to think that she would be very interested in potentially doing something with this motion. I'm not entirely sure what, but maybe suppressing some evidence or something like to that effect. Maybe not dismissing the charge because they've kind of styled it as a motion to suppress and dismiss. But I
think the dismissal was the idea that the attorney-client privilege is so sacred that it's a due process violation, and you have to dismiss the whole.
But you can. But if she suppresses a substantial amount of information, they can go up to the 11th Circuit on that. So it's
the order itself says I'm reserving decision on the motion to suppress. I don't think she's seriously still,
considering dismissal.
Yeah.
Yeah, and the question is just to what extent. No, well, and the question is to what extent, though, what she suppresses is tantamount, as you said, for at least some of these counts, to a dismissal, because it would take away a big part of the case. But yes, Ben, I can't put a percentage on this one. I just don't know, but I would not be surprised if she, to some extent, grants the motion.
All right.
Incidentally, I also left out. This evidentiary hearing will also be on another issue, which is on the particularity requirement of the warrant, and this has to do with parts of it were very clear. You're supposed to seize documents with classified markings, and that's basically what they did. But apparently, it also said there was also language like national defense information, which is sort of a term of art, and it wasn't defined. It was defined in the affidavit, but not in the attachment, and it's unlikely that all the agents read the affidavit. It's totally unclear to me what she would learn at an evidentiary hearing that would clarify to her. What is she going to interview the agents and say, what were you looking for? How did you interpret that? What does she need?
All right. So we need to move on because we got to go to audience questions. But Anna, I want to ask you very briefly, what was the afternoon session on Tuesday?
Yeah, so it was on this very subject, which was the validity and sufficiency of the warrant. There were two issues. One is this question of whether there should be a Franks hearing, which is a hearing that is held regarding allegations of false statements or omissions in the affidavit that is used to seek a warrant. And I think that one, Judge Cannon did not grant the Franks hearing. She denied that in this motion or this order that was released earlier today. I got the sense that she was not particularly interested in this argument regarding the omissions. I'm actually really surprised, though, that she granted this evidentiary hearing on the second part of the hearing, which related to whether the language in the warrant was sufficiently particular to meet the particularity requirement of the Fourth Amendment. Because at one point, as the hearing was about to end, she said to Emil Bovey, the question that the court has to decide is whether the language is sufficiently particular, because he was trying to make all these other arguments about getting inside the heads of the agents and all this kind of stuff, and trying to get into issues that are raised in their motion to compel and their motion for selective prosecution. But she said to him, no, the question is, I look at the language and I decide whether or not, it's sufficiently particular. And then she said, and it seems like it is. And that's and so I left the hearing thinking, oh yeah, she's definitely gonna, just deny this motion. And then today we get this order in which she says the court agrees with defendant Trump that there are sufficient ambiguities in this language in attachment B, which just before we wrap up, I'll read you the part she's concerned about is information. This is about property to be seized. In under attachment B, information including communications in a form regarding the retrieval, storage, or transmission of national defense information or classified material. She's focused on national defense information. And then in the next sentence, any government and / or presidential records created between January 20th, 2017 and January 20th, 2021. She's focused on the ambiguity of presidential records in the warrant. I don't know what this evidentiary hearing will look like on those matters, but it is very interesting and surprising based on what she said in the hearing that she granted this evidentiary hearing.
All right. We have 6 audience questions. We're going to get through them all. Michael asks, in the gag order session, did Judge Cannon express even one iota of concern for the safety of the FBI agents or the nature of Trump's lie about the FBI?
I mean, look, I think at one point she did say that, of course, safety is important or something to that effect. I would need to look back at my notes and / or a transcript to get the exact language. But her main thing is just that she was focused on the legal kind of inquiries. And she really was very resistant to that because David Harbaugh kept making the argument that he kept saying, we all know the environment that Trump has created and kind of, trying to articulate the idea that this is a guy who he says things and then people do things and he knows it. And that's kind of the theme of what David Harbaugh kept saying over and over again. And she was just seemed to be very resistant to the idea that there's just this environment that everyone kind of knows about. Again, she's so particular about you've got to develop the factual record and you've got to have this in evidence and it's got to be an exhibit and you can supplement the record or you can't supplement the record or you can. And, so that was the kind of thing that I think she's just very resistant to is just representations being made without some kind of, paper to put into evidence about it.
All right. Michael asks, I've heard some commentary that DOJ's aggressive prosecution of January 6th offenders has helped to limit organized group efforts to engage in organized violence around elections because people who engage in that know DOJ will prosecute. But if SCOTUS and Fisher hands down a ruling that is very favorable to the January 6th defendants, will that risk removing the disincentive and tempting groups like the Proud Boys to engage in election-related violence? Roger, how big a boon to the violence-engaged community would it be to have a favorable Fisher ruling?
I think it would be a moral, it would be a big victory for everybody that hates Merrick Garland, symbolic victory. And it would be a blow that, we see the way Trump he talks about the Russia hoax. There never was a finding of a Russia hoax, but the Mueller report and the way that Attorney General Barr handled it gave those forces a win, and the nuance of it is all lost. And this would be a big win for all of those forces, regardless of the nuance. And how moderate in actual impact, it is likely to have. That's sort of the best I can do. I don't think, unfortunately, that even right now that things are great as far as having, taught the forces of violence any sort of lesson. They seem to be mobilizing. They seem vigorous. They seem in I can't think of the word, but all of this seems to have backfired in some sense. That everybody is just the forces that caused the violence are fully engaged.
I will just add to that the Justice Department has a lot of tools to prosecute people who engage in violence. This one, the most violent people are not charged with this crime. The people who are charged
they're charged with others in addition
as well, right? These are not the seditious conspiracy people, right? These are not these are the people who kind of and this really has application most of the time only with reference to attacks on things like the Capitol, because most other proceedings you're going to be using a different statute. So look, it would be really bad for January 6th prosecutions. You'd lose at least one charge in a couple hundred of them. But I don't think it would materially generally erode the Justice Department's ability to prosecute violent political crimes in other contexts. Okay, Laura asks, what do you feel are the most important points in Norm Eisen and Joshua Kolb's piece, Prepare for a 2024 Mini Trial in Trump's DC Prosecution? So this was a piece we published in Lawfare, I believe on Monday. The main gist of which was that we could expect, in the event that the court were to rule partially for Trump in the immunity case, which is a distinct possibility, a kind of mini trial as Judge Chutkan tries to figure out how to apply the Supreme Court ruling, and that mini trial, if not the trial itself, would likely happen over the summer. I thought Norman Josh's point was a very interesting one, which was why we ran the piece. I don't know how to handicap the likelihood that the mini trial, as opposed to a full-fledged trial, is going to happen. That depends entirely on the way the Supreme Court rules. But I thought it was an interesting issue to flag, and I think it's a very likely possibility as the court, the district court, figures out how to apply whatever the Supreme Court ends up ordering. Jim asks, why did Judge Merchan allow Trump to attack jurors? And the answer is he didn't. He allowed Trump to attack the jury. And the reason he did it, first of all, the entire gag order will lapse with sentencing. You can't stifle somebody's First Amendment rights forever, right? This is something that he is allowed to impose for trial management purposes. When the trial is over, the gag order goes with it. And he seemed to acknowledge that the other day. So this is really a question of how much it diminishes now that witnesses are not at issue anymore, that the thing isn't live. The jurors are the most sensitive matter here, and I think he actually said that he wished he could sustain the protection, but he understands that he can't, and so he that's gonna suck for them. I did notice that unlike Anna's friends in the Fulton County special grand jury, none of these jurors have raced to the press to talk about their experience. And I do think that reflects the fact that Justice Merchan is almost certainly right that they find the atmosphere pretty menacing. Two more questions. Michael asks, here's a potential disposition in Trump v. US that I haven't heard anyone suggest. The court could set the case for re-argument in the fall. Do any of you think that this is a possibility? So yes, it's a possibility. It's a fairly remote one, just because the court doesn't do that very often, but they do it sometimes. And sometimes in very high profile cases. If I remember correctly, Brown v. Board of Ed was held over for re-argument and was re-argued. I may be misremembering that, but I don't think so. And so, yeah, it is always possible that they could do that. It is also possible, as they did today in the EMTALA case, the emergency medical care case, they after full argument and briefing, dismissed it as the writ as improvidently granted. That is also always within their power to do. You generally don't bet on them doing those things. Usually when they take a case, have it briefed and fully argued, they tend to mean to decide it. Do either of you have thoughts on that? Okay,
Yeah,
last question. If Judge Cannon is so concerned with the appropriations for Smith and Company, would it make sense to point out the amount of extra funds that are being spent to assuage all her fears and answer all her questions? So I take it that that question is meant somewhat in jest, but I will just say in response to it that the issue is not how much money Jack Smith has spent. The issue is whether the source of that money is lawfully available to him. And along the way, of course, it's always fun to point out how expensive investigations have been, although that is often a bad argument because some investigations, like the Mueller investigation, I think took in more in seized assets than it cost. And so, you kind of live by that argument. You can die by that argument too. All of which, 4 minutes early, brings us to the end of this week's Trump's Trials and Tribulations. You will notice that it has gotten dark over Roger's right shoulder because it is evening in France, even if it is always broad daylight in the Mar-a-Lago studios. Folks, become a material supporter of Lawfare. There are 400 of you or something watching on YouTube. And I'm telling you, it's more fun here in Zoom because you get your questions answered. You get to participate in this glorious chat that we call the Greek Chorus that comments and greets each other. They have a great time. You can become part of that. All you have to do is go to lawfaremedia.org/support, become a material supporter. The option is always available. Remember, it is a federal crime to give material supports to designated foreign terrorist organizations. It is a virtue to give material support to Lawfare. We hope you do. From the Mar-a-Lago bathroom studio. Well, Anna has something to say.
I have a very important announcement for listeners of Trump Trials and Tribulations. As everyone knows, I have spent weeks, even months, being Fort Pierce, the biggest hater of Fort Pierce, Florida. After spending nearly a week there, I will say I've really come around.
Whoa.
Yeah, it's a big
She's a convert.
Yeah, I'm a convert. Anyway, Fort Pierce is great. It was really fun to be writing all weekend, but at least I was writing by the beach. So that was great. And yeah, that's all I've got to say. Just wanted to make that announcement. I did have a margarita and some fish tacos. So.
All right, but the food is still better in Lower Manhattan, right?
The food is still way better in Lower Manhattan, and like the general like just everything in Lower Manhattan is still probably preferable, and it's still really hard to get to Fort Pierce, but once you are there,
It's not that bad.
great. Not that bad.
All right. On that cheerful note, this has been Trump Trials and Tribulations. Thanks to the great Anna Hickey, who manages these live streams. And we will be back maybe tomorrow, maybe Monday, maybe both, but certainly next week. And until then, be great Americans.